Okay, very good. Well, good afternoon, everybody. Appreciate you making time to be here today. I'm Justin Horvath. I'm President and CEO of the Shiawassee Economic Development Partnership. Really excited to be able to host this educational webinar for all of you today. A couple housekeeping items before we get started. As if you're just jumping on, we are recording this meeting, so some folks were not able to make it. As well as I'm sure some of you might want to come back and hear the presentation or share it with some of your coworkers. So we are recording this. And we also mentioned as we were getting started, we would ask that you remain muted for the duration of the event for noise purposes. But if you do have questions during the presentation, please put them in the chat. And Ann will be able to answer those as we get toward the end. So one more item to be clear too, this is obviously meant to be educational for all of you as stakeholders. So if you have specific questions for your own organization, your business, your local unit of government, definitely reach out to your own labor law attorney. But if you don't have one, I know that our friends here at Warner Norcross and Judd would be happy to help. So before we turn it over to our presenter, Ann Steen, I wanted to make an introduction. So I think I know pretty much everybody on this call, but for those of you that are not aware of me or our organization, Shiawassee Economic Development Partnership is the economic development group for Shiawassee County. We focus on trying to grow the local economy. We work in business development, workforce development, and real estate development. So we work with a number of you on a number of different projects, but we do rely on the support of our investors to be able to do things like this. Many of you on this webinar are current investors in our program, and we thank you for that partnership. Some of you are not investors, and so we're excited as of 2 days ago to bring on board for the first time our first ever Investor Relations Manager, Alexis McDowell. She has joined us today, and I'd like to have her maybe just say hi to everybody and introduce yourself. She will be in touch with you if you are a current investor or a new investor. So, Alexis?
Hi, thank you, Justin. Like you said, my name is Alexis McDowell. I'm a resident in Shiawassee County my entire life. I'm excited to meet with each and every one of you if we get the chance. But yeah, it's been 16 years since Justin hired anybody, so that's a huge ordeal. So I'm excited to meet, like I said, excited to meet with everybody and see all the opportunities that I'm given within the next couple of months or years.
All right. Thanks, Alexis. We will be issuing a press release shortly, and in that will be her contact information. And maybe, Alexis, if you want to put that in the chat, if anybody wants to get a hold of her, please do. So I thought this would be a great opportunity to make that introduction with so many of our stakeholders on the line. So now for why we're here today. We heard from a number of you that there was significant concern over this new Earned Sick Time Act law that was coming down from the state of Michigan. And so we have partnered with our friends here at Warner Norcross and Judd, great law firm. They've done a lot of work in Shiawassee throughout the state to be able to provide this education so that you can get some overview, get some questions answered today. And as I mentioned, if you need follow-up information, they'll be available to do that. But clearly, by the virtue of the turnout of this event, it's a huge topic. We've put on educational events for many, many years, and this is the largest turnout that I've seen for one of these. So this is obviously a very key point of concern for a number of you. So very grateful for Ann Steen, who is a labor and employment attorney at Warner Norcross and Judd, who has joined us today, who is going to go through a very substantive presentation. And as mentioned earlier, there will be an opportunity for Q&A at the end. We'd like to wrap this up around 1 to be respectful of everyone's time. But please put your questions in the chat as we go through, and we'll try to hit those as we get toward the end, or maybe even during the presentation. So I think that I'm going to turn it over to Ann. Thank you for joining us. Thanks for the partnership with Warner Norcross and Judd, and the show is yours.
All right, thanks so much, Justin, and thanks, Jody, for your work and putting this all together. I know that can be quite an ordeal. So we're going to just jump right into it. Today, we're going to talk primarily about the Earned Sick Time Act, but a little bit about the Improved Workforce Opportunity Wage Act, which were both affected by the recent Supreme Court decision that you probably heard about here, there, or everywhere that that brought you here today. So this is kind of an overview of what we're going to talk about, kind of what happened. Some of you who have been sort of following this may remember that there was a previous court decision and then that got reversed. And we're going to just very briefly go over that history so you kind of understand what happened and what led to the Earned Sick Time Act being reinstated. And then we're going to talk about what to expect going forward. We're going to get very detailed as far as what is covered in the Earned Sick Time Act. So for that reason, I am going to wait till the end to cover any questions, just because we are going to cover a lot of the substance of the act. So in order to avoid answering questions that we're going to answer later on in the substance of the presentation, I'm just going to wait until the end to address any questions if we have time to do that. And then we're going to talk about, kind of practically speaking, what your next step should be in light of this new info. So how we got here. So, legislative history and, judicial history doesn't tend to be super interesting, but this one is a little bit juicy. So the Earned Sick Time Act and the Improved Workforce Opportunity Wage Act, IWAWA, began as ballot initiatives in 2018. Supporters got the requisite number of signatures to get it on the ballot. When that happens, the legislature has a few options. They can adopt the measure as it's written. They can allow it to go to a vote of the public, in which case it will be more difficult for the legislature to amend it later on if it gets approved by ballot measure. Or they can allow it to go to vote on the ballot, but they can propose their own version or their own alternative language relating to the same topic. So those are kind of the three options they have when a group gets the requisite number of signatures to put something on the ballot. The legislature saw that, the writing was on the wall. This ballot measure was probably going to be passed by popular vote. So rather than allow that to happen and sort of tie their hands with respect to amending it down the road, they adopted both of these measures in September of 2018. Now, that would have made them effective. It's 90 days after the end of the legislative session. So usually it's somewhere around late March, early April of the following year, 2019. Now, between then and 2019, there was an election. And following that election, while the legislature was still in lame duck session, so in other words, before the new legislature took over, they substantially amended the Earned Sick Time Act and reduced employee entitlements under this statute, and then also under the Improved Workforce Opportunity Wage Act. And those were signed by Governor Snyder on his way out the door on December 14, 2018. Some groups challenged this, said this is unconstitutional. The Constitution gave you those three options that I previously described. You can't choose option 4 and adopt it and then immediately amend it, while you're in the same legislative session. In 2022, some of you might remember this, a court of claims agreed with that group and said, yes, this was unconstitutional. We're going to have to reinstate the Earned Sick Time Act. And then for a period of about 6 months, from July of 2022 until January of 2023, it looked like the Earned Sick Time Act was going to come into effect in February of 2023. In January of 2023, the Court of Appeals reversed that decision and basically said, nope, we think what they did was fine. The amended version of these statutes get to stay in place, at least until they were appealed. That decision was appealed to the Michigan Supreme Court, which heard it last year. And in July of this year, 2024, the Michigan Supreme Court decided they agreed with the Court of Claims. Basically, it was unconstitutional to adopt and amend the Earned Sick Time Act in the way that the legislature did it. And so the Earned Sick Time Act is now going to become effective in February of 2025. They gave employers 205 days until February of next year to comply with the Earned Sick Time Act and the IWAWA requirements. Importantly, there will not be back pay. So in other words, these should have been effective according to the court in 2019. The court has said we're not going to go back and require employers to comply for those, 5 years, 6 years that they should have been effective. But starting in February of next year, they're going to be effective. You're going to have to comply with them. No penalty, et cetera, for not complying in the past. Now, this is a question I get all the time. Now, we've already seen this happen once where the court decided this was, unconstitutional, and then they got reversed. So, is there any uncertainty about whether that could happen again? Could we, go through all this work to comply and then have this decision reversed? The decision that we have now is from the Michigan Supreme Court. That's the end of the line as far as court decisions. You can't appeal that. The state could file a motion for rehearing. They probably won't. Or what is more likely to happen, and sort of is a little bit underway, is that the legislature could choose to amend the Earned Sick Time Act. And in fact, they did just last week propose a bill which will amend it, although not super substantially, at least as far as the bill is in its present form. And we will talk about that at the end of the presentation too. So what are the consequences of the 2024 decision? Earned Sick Time Act becomes effective February 21, 2025, meaning by that time, employers need to be in compliance. So let's get into kind of the meat of what is in the Earned Sick Time Act. The first threshold question always when you're dealing with a new employment requirement is what kind of employers are covered, right? A lot of small employers are used to being exempt from employment requirements, the FMLA, and previous to the Earned Sick Time Act, the Paid Medical Leave Act, which is what was effective in Michigan or is effective until February 21, 2025. So who is covered? The Earned Sick Time Act says that an employer is any person, firm, business, educational institution, et cetera, that employs one or more individuals. In other words, all employers. There is not a small employer exception to the Earned Sick Time Act. There is slightly different requirements for small employers versus large employers, but as you'll see, what constitutes a large employer is really not all that large. So the employer coverage, it's everybody. Everybody who employs someone in the state is going to be covered by the Earned Sick Time Act. And that is a very significant departure. Previous to this, and under the currently effective Paid Medical Leave Act, only employers with 50 or more employees were required to comply with that statute. So a lot of small employers are not used to having a state level or any really paid sick leave requirement. So this is definitely bringing a bunch of people into the world of paid sick leave that were not in it before. Now, who are employees? Employees are pretty much everyone, somebody who is employed by an employer, with the following exceptions. It does not include independent contractors. This has been recently clarified by the Department of Labor and Economic Opportunity. The statute itself is actually so broad that it wasn't totally clear from the language of the statute itself whether it did exclude independent contractors. We have always taken the position that it probably did, and that was confirmed by the Department of Labor in some FAQs they put out a few weeks ago. And then probably an individual whose primary work location is not in Michigan is also not covered by the ESTA, although that is not explicit in the act. Now, I want to stay on this point just for one more related to one other issue, which is this too is a pretty significant departure from what we currently have in the state of Michigan. The Paid Medical Leave Act, which remember I said the legislature took the ESTA and they amended it substantially. The amended version of that is what we have in Michigan right now, the Paid Medical Leave Act, the PMLA. And under that statute, there were lots of exemptions. So even employers who were over the 50 employee threshold could exempt a lot of employees, exempt employees, people who were covered by a public or private CBA, certain transportation employees that worked very part-time, temps, etc., were excluded from the PMLA, even for employers that were covered. Those exemptions are all gone under the Earned Sick Time Act. Pretty much all employees, and yes, including part-time employees, are covered by the Earned Sick Time Act. So they need to be provided with the entitlements that I'm about to describe. So that's a pretty significant departure from what we have had as far as a paid sick leave requirement in Michigan up to this point. Rehired employees, another sort of distinct piece of the ESTA that was amended out. Employees who are rehired within 6 months are entitled to retain their previously accrued earned sick time. So if you fire somebody or they leave and they come back within 6 months, you need to reinstate their paid sick leave. All right, so let's talk about how much leave, how does it accrue, does it carry over, how can employees use it? These are kind of the principal pieces. So leave accrual. Employees need to accrue at least 1 hour of earned sick time for every 30 hours worked. This is different than under the Paid Medical Leave Act, which accrued slightly slower than that. Now, you'll remember I just said exempt employees are not exempt from this particular statute as they were under the Paid Medical Leave Act. So what do you do for exempt employees, right? They aren't on an hourly, they're not usually punching a clock. What do you do as far as assuming their work period? You can assume that they work 40 hours per week unless they have a normal week that is less than that, in which case you would use their normal week. As far as accrual, there are no accrual limits. This is also different. So employees can continue to accrue time. We do have some options as far as limiting how much they use, but as far as how much they accrue, it can accrue indefinitely. Now, recently, it became clear, the Department of Labor put out, again, those FAQs that they will permit employers to front load all the leave that employees would otherwise be entitled to under the Act for the year at the top of their benefit year. We thought this was probably the case, and this was, recently confirmed by the Department of Labor. Importantly, though, there is no exception to the ESTA for overtime, etc. So you still need to be, even if you front load time, you will still need to be clocking the hours worked by your employees in order to ensure that they're receiving 1 hour of paid sick leave for every 30 hours worked, and that whatever you front loaded them hasn't been exhausted. And of course, still no accrual limits. Now, leave carryover. The Earned Sick Time Act has no carryover limits. So in other words, employees, once they accrue the leave, they may carry it over from year to year. There are only usage limits, which we're going to get into. So this slide tends to freak people out. The next slide will hopefully give you a little bit of comfort. So even though employees are allowed to accrue time and carry it over from year to year, we can limit how much employees use in a 12-month period. So the limits on usage relate to how large the employer is. So large employers under the Earned Sick Time Act, which is just employers with 10 or more employees, may limit the earned sick time that an employee can use to 72 hours of paid sick time per benefit year. Small employers, those with 1 to 9 employees, can limit it to 40 hours of paid sick time and 32 hours of unpaid sick time per benefit year. So even though your employees may have accrued much more time than that and may have carried it over from year to year, we can limit how much they can use annually or in a benefit year, depending on how you designate that 12-month period, to 72 hours for large employers, 40 hours of paid time for small employers, plus 32 hours of unpaid time. A benefit year is any consecutive 12-month period. So many employers use a calendar year. You could also use like an anniversary date, 12 months from their anniversary date, or a different measure as long as it's a 12-month period, consecutive 12-month period. Now, this next point is another one that tends to really distress listeners of this presentation. One of the things about the Earned Sick Time Act that is probably the most impractical piece of it, and to me seems to be the most obvious piece of it that shows that it was a ballot measure that never actually went through the legislative process, is that it requires employers to allow employees to use earned sick time in the smallest increment that is used for attendance or absences of other time off, but not greater than hourly increments. So in other words, an hour or down to what you can calculate. So that could be very, very small amounts of time. 90-day waiting period for new hires. You can require employees who are hired to wait 90 days to begin using their earned sick time, although they do start earning it from their date of hire. let's see, qualifying reasons. So what can employees use this time for once they've accrued it? What can they use it for? So the reason I have this one bullet point in red at the bottom is because this is the change from the prior entitlements that were available to employees who were covered by the Paid Medical Leave Act. But these are all the reasons altogether. So the first few were already available if you were an employer that was covered under the Paid Medical Leave Act. Your employees could use paid medical leave for those reasons. The last bullet point is one that was amended out basically and is now effective again. Meetings at a child's school or place of care related to their health or disability or the effects of domestic violence or sexual assault. The others are things that you might predict for the most part, along with a handful of others, but mental or physical illness or injury of the employee or their family member, medical diagnosis, treatment, etc. Pretty broad. Who is a family member for purposes of using this time off for the employee or the employee's family member? So it is a child, including a child of a domestic partner, grandchild, a spouse or a domestic partner. The items in red are distinctions from what we've previously had. Parent, grandparent, sibling, and then this interesting category of any other individual related by blood or affinity whose close association with the employee is the equivalent to a family relationship. This is going to be an interesting one. How are we going to determine what type of a relationship qualifies as the equivalent of a family relationship? I don't know. The act is not particularly clear on that point, and the LEO, the Department of Labor and Economic Opportunity, has kind of declined to touch this one so far. At some point, we may see more guidance on it. It may be part of future amendments, but for right now, this is all we have. So that is an interesting change and addition from what we have previously been obligated to comply with. Supporting documentation. This is also quite different under the Earned Sick Time Act relative to what was required under the Paid Medical Leave Act. So under the Earned Sick Time Act, employers can require supporting documentation be provided in a timely manner, but only if an employee uses more than 3 consecutive days of paid sick time. Employers also need to pay any out-of-pocket costs incurred by employees in securing that documentation, and we cannot require documentation that explains the nature of the illness or details of any violence. If you read through these, you saw that there are a number of issues related to domestic violence that are eligible qualifying reasons for leave. So talking about the first bullet point here, we can require supporting documentation, but only if the employee uses 3 consecutive days or more of earned sick time. You may remember from a couple slides ago that employees can use earned sick time in very, very small increments of an hour or less. So in other words, if you have an employee who takes a half day off, if you have an employee who takes an hour off, if you have an employee who shows up 15 minutes late for work, and they say, assuming that your payroll system can calculate absences in that increment, and they say this time off is for earned sick time purposes, our ability to verify that via documentation is pretty limited under the Earned Sick Time Act. And I will spare you a little bit of suspense for my later slide about the bill. This is not something that is in the original bill proposed to amend the statute. So for right now, this is what the Earned Sick Time Act requires. So that is pretty different. So if you have a policy of automatically requiring documentation from a physician for absences of employees under your sick time policy as it exists today, you will need to amend that if you plan to use your sick time policy to comply with the Earned Sick Time Act. Also, employers must pay out of any out-of-pocket costs. So in other words, if your employee incurs a copay in obtaining the documentation that you're requiring for purposes of the Earned Sick Time Act, you have to pay them back or reimburse them for those costs. Employer notice. So this is something you are going to have to think about doing prior to February 21, 2025. There is a poster, the LEO has already put it out, that you will need to put up. And then employers are also required to provide written notice to employees. I would probably include this in an offer letter as some sort of appendix, but whatever you're providing to new hires in their new hire packet, this should be one of the things that they receive. And you should also be providing written notice to your employees prior to February 21, 2025 regarding how you plan to comply with this act. There's a specific requirement if you have employees, more than 10% of the workforce that speaks another language, you need to provide this notice in that language. If it's one of the ones that the LEO has translated, they have a number of translated notices. If they don't have them out already, they will be putting those out. So if it's one of those languages, you'll need to provide those to your employees if that applies to you. Record keeping. Employers need to retain records under the Earned Sick Time Act for 3 years. Failure to maintain records is a big deal under the Earned Sick Time Act. It's not always under every employment statute that we deal with. Sometimes it basically means a slap on the wrist if you fail to keep your records. But in the case of the Earned Sick Time Act, it actually provides the employee with a presumption that you violated the Earned Sick Time Act if you don't have adequate records that show the things required by the Earned Sick Time Act. So you need to keep records of the hours worked and earned sick time taken by your employees. Now, right now, there is no exception to this hours worked requirement for exempt employees. Is this, as you'll see, I was going to show you well, that's maybe a little bit neither here nor there, but there is no exception for exempt employees. Most employers don't keep hours for their exempt employees. The Earned Sick Time Act says we need to keep records of hours worked and earned sick time taken for our employees, and exempt employees are covered by the ESTA. So will be interesting to see if that gets amended, if there's any additional guidance on that. But for now, that's what it states. Enforcement. This is also pretty substantially different under the Earned Sick Time Act as opposed to the Paid Medical Leave Act, which was previously in place or is in place until February 21. Employees can file a claim with the LEO. They can also file a civil action in court, and the statute of limitations is 3 years, which is a pretty significant extension from how long employees had to file this sort of claim under the Paid Medical Leave Act. Retaliation. The Earned Sick Time Act specifically prohibits and defines retaliation. Attendance policies may not treat earned sick time use as an absence that can lead to or result in retaliatory personnel action. So if you have a zero tolerance attendance policy, you're going to need to take a look at that to make sure that absences for time off under the Earned Sick Time Act are exempted from that policy. And again, employees are entitled to use earned sick time in very small increments, potentially increments that might make them a little bit late for work. And they should not be docked according to your attendance policy if that time is being taken for earned sick time purposes. Another interesting feature of the Earned Sick Time Act is that it creates a rebuttable presumption of retaliation if an employer takes adverse personnel action against a person within 90 days after that person files a complaint with the LEO, informs somebody about an employer's alleged ESTA violation, cooperates with LEO or another person in the investigation or prosecution of an alleged ESTA violation, opposes any policy, practice, or act that is prohibited by the ESTA. So if they complain your policy is not complying with the ESTA and they get fired within 90 days of that, they have a rebuttable presumption of retaliation. Or if they share with another employee, hey, you have rights under the Earned Sick Time Act, and 60 days after that, we demote them or dock their pay for some reason, they automatically have a rebuttable presumption that we retaliated against them for their protected activity under the Earned Sick Time Act. So pretty significant, an interesting feature of this particular statute that was, it's not unheard of in employment law, but it's pretty rare. And it's pretty, it gives a lot of teeth to the enforcement mechanisms of this particular statute. Another few features that are important to employers to understand as they're beginning their process of complying with this act. No payout of unused paid sick leave at year end or on termination. This is a key one, right? I previously said employers can't limit accrual, right? And employees need to be allowed to carry it over, at least at this point, from year to year. So this is a crucial and beneficial feature of the ESTA, which is that even though employees are allowed to accrue potentially large amounts of earned sick time, we are not required to pay any of that out on termination, even if they have a large bank. So in other words, it is very possible that employees may accrue large amounts of earned sick time that they can't and don't ever use, and it doesn't create a financial liability on the employer. Another important feature, earned sick time, as with other forms of vacation, holiday pay, etc., does not need to be counted as hours worked for purposes of overtime. And employers can, and I'm going to say this very clearly and carefully, we can count other paid time off, including vacation, personal, or PTO, toward leave entitlements, but this is the key piece, as long as it fully complies with the Act's requirements. For most employers' PTO policies, you are going to need to make changes to them in order to comply with what the ESTA requires. So everything I just said, basically, as far as how employees can use it in terms of the increments, carryover, how fast it needs to accrue, all of those requirements, you need to ensure, if you're going to say my paid time off, I'm using my bucket of PTO for purposes of complying with my obligations under the Earned Sick Time Act. If that's your plan, you need to ensure that that paid time off complies with all the requirements of the Earned Sick Time Act. Otherwise, the LEO, potentially courts down the road, are going to say you weren't actually in compliance. You didn't actually give employees what they were entitled to under this act, because even though you gave them paid time off, they couldn't use it in the increments that they were allowed to use it in under the ESTA, or you required them to forfeit it at the end of the year and the ESTA allowed them to carry it over, etc. So that is, I want to be very careful with that bullet point, because I do fear sometimes that employers see that bullet point and think, oh, I provide at least 72 hours of paid time, I'm good to go. That is not the case. You need to ensure not only that you have enough time, but that the time that you're providing complies with all the other obligations. So let's talk a little bit about that specifically, right? If we currently have a PTO policy with an accrual of 72 hours or greater, is this sufficient? Probably not by itself. Maybe, as long as it meets all of the ESTA's other requirements. So needs to be able to be used for all the same reasons, under the same conditions, and be accrued at a rate equal to an hour for every 30 hours worked. A couple of the things we didn't really get into, but another thing that the ESTA requires, or sort of creates restrictions around, is how much notice we can require employees to give before they take time off. For foreseeable leave, we can require them to give about 7 days. So if you have a PTO policy that requires employees to put in all their PTO at the start of the year, that is not going to work for purposes of meeting your obligations under the ESTA. And then you have to allow them to use it in the same increments and carry it over, etc. If we can't currently have PTO, can we reduce it by the number of hours required under the ESTA and classify those for the ESTA absences? Yep, you just have to make sure you're meeting all your other obligations under the Act, as we just discussed, right? Uses, accrual, time increments, carryover, etc. I do have a number of, questions related to this on my desk at the present moment. A lot of employers are thinking through right now how to strategize this. Do we create a separate bucket? Do we decide to lump it into our existing PTO? What does that mean for retention? What does that mean for recruitment? How much leave do you give, etc.? Briefly about union contracts. So the Earned Sick Time Act and IWAWA, the Improved Opportunity Workforce Opportunity Wage Act are floors, and your collective bargaining agreement cannot go below them if you have employees covered by a CBA. What do you do for employees that are in the middle of a contract that will not expire before February 21, 2025? The ESTA actually rather helpfully addresses this situation. If an employer's employees are covered by a CBA in effect on the effective date of this act, the act applies beginning on the stated expiration date of the collective bargaining agreement, notwithstanding any statement in the agreement that it continues in force. So in other words, you don't have to deal with this until the expiration of your current CBA. But you will want to think through that when you're negotiating your next contract. Need to develop your plan, communicate it to the union, be prepared to bargain over it. Don't have to agree, but need to bargain over it and be prepared to press to impasse if necessary. We absolutely can't go below the floors set in place by the ESTA, which in some ways is nice, right? There's no, we simply have to comply with at least those minimums. So when you're negotiating a future contract, that is at least the starting point from which you all have to operate. So that's what to do with union contracts. I want to speak briefly about the bill. Oh, it wasn't introduced yesterday. It was introduced about a week ago. This bill doesn't do a whole lot as far as adjusting the substantive requirements. So adjusting most of what I just described to you. It does two things. One, it clarifies for sure that independent contractors are excluded from the ESTA. It revises the definition of covered individuals so that it's clear it does not include independent contractors, which we already kind of knew because the Department of Labor put that out in their FAQs and was probably always logically going to be the case. The other thing it does is more interesting and is a more important change. It creates a front-loading carryover exclusion like the PMLA, the Paid Medical Leave Act, the statute that is currently in effect. Under the PMLA, if you provide the entitlement at the top of the year, benefit year, whenever that is, you don't have to allow employees to carry it over from year to year. This amendment, proposed amendment, would allow the same thing. If you provide 72 hours at the beginning of the year, then you are not required to allow employees to carry it over from year to year. Makes a lot of sense, right? If you're giving everything to employees up front, as opposed to requiring them to accrue it slowly over time, then they don't necessarily need the benefit of being allowed to carry over the time that they have only very slowly accrued throughout the year, right? They're getting kind of the benefit of this obligation right up front, and there's no need to allow them to carry it over from year to year. So that would be a pretty significant difference, but that is the only other substantive change that was in the bill as it was introduced. Now, of course, there could be changes to these bills as they go through the legislative session. The legislature doesn't have, I don't believe, a ton of days left of legislating this year. They have a break in November, and then they usually wrap up sometime in December. So there's only a few days of actual session left this year, but we'll certainly be following this and be interested to see whether there are changes that get made and whether these advance or look like they're going to get passed. All right, so what do employers need to do first? I just gave you a lot of information. It is a very significant change from the existing landscape of paid leave in Michigan. And I feel, we kind of put these next step slides together because a lot of people were wondering, where do I even start with this? So I would start kind of at the top. Review your time off policies. Do your time off policies need to be increased or revised so that they will comply with these new minimums? What about your CBAs? Check the expiration date on your collective bargaining agreements if you don't know when they expire or if they might expire somewhere very close to the effective date of the ESTA. Consider the financial and operational impact. Will these changes increase your labor costs? Run some calculations. How is potentially more or easier to use paid time off going to impact you operationally and from a staffing standpoint? Do you need to consider whether you need access to or access to more or additional temporary employees. If you are going to have employees that can take more time off, depending on kind of what your existing paid time off policies are like, and depending on what your staffing situation is like. And then how to structure and administer attendance policies and discipline going forward. Again, if you have a kind of no fault or zero tolerance attendance policy, you're going to need to look at it and consider how you might need to revise it in light of the ESTA and its expressed restriction on docking employees for time taken under that act. For different types of employers, this is going to have a different type of impact. Some employers don't have a lot of attendance issues. Some have many attendance issues, lots of attendance issues, and this might create a more significant change for them. Look at your benefit year. If you are an employer that is covered by the FMLA, what is your benefit year? You know, kind of how is that calculated for your employees under that statute? Thinking about how your vacation, PTO, and sick leave are timed out right now and how you want to do that for purposes of your ESTA obligations. What are you going to use for employees who did not previously receive paid sick leave? Do you have part-time employees who were not covered by your PTO policy previously? Many employers don't provide PTO to part-time employees, right? How is that going to work? And then coordinating benefits. Do you want to rob Peter to pay Paul? So in other words, integrate your ESTA obligation with an existing PTO policy, or do you want to separate them out? Do you need to or want to coordinate ESTA time with your other sick time, short-term disability, salary continuation policies or practices? And considering again, FMLA, how is time off calculated for purposes of employees' FMLA obligations? How would that correspond here? Communication, developing a written ESTA policy for employees and managing employee expectations. You are going to have probably some of you employees who read a headline about the ESTA and think they suddenly have 72 more hours of time off. That may or may not be the case, you know, and they probably won't understand, you know, how slowly it needs to accrue. And they certainly won't know what your plan was or how you intend to comply with it unless you have communicated that to them. So you may want to head that off by having a game plan in place and communicating it clearly and proactively with your employees prior to the February 21 effective date, so that you don't get employees who are coming in saying, hey, I just read about this, you know, what are you doing to comply? I think I get 72 more hours, and now you have disgruntled employees. Are there other stakeholders who need to know, who need to understand that your employees will take off time for this purpose? Do you need to train your supervisors not to dock attendance for employees who are off for this reason, depending on how you handle call-ins and how you handle employees who are absent? If you use a temp agency, temporary employees are potentially entitled to time off under the ESTA. Is your temp agency complying? Or will they indemnify you if they drop the ball and they fail to provide employees with their requisite time off under this statute? So certainly another thing to consider that has not always been on employers' radar under previous entitlements. Record keeping. What are your HRIS and payroll systems capable of tracking for ESTA compliance? As I mentioned, employees are entitled to use this in potentially very small increments. You're going to want to think about how your existing payroll software, your existing systems might be able to handle the tracking and record keeping and other aspects of the ESTA compliance that we just described. If you use a third-party payroll provider or leave administrator, will they be keeping records, and how will you access them if or when you discontinue that relationship? If you have a third-party payroll provider, are they familiar with the ESTA, and is this one of their, you know, options? As we mentioned, you need to keep those records for 3 years. And if you decide to switch providers, you need to ensure that you have the records that you need in order to do that. ensuring that you have access to those in your first contract with those providers, or ensuring that as you're ramping up your compliance with this statute, that you make clear to those providers that you will need that access to those documents should you ever part ways, is another thing you'll need to think about. If this has been totally overwhelming to you and you have no idea how to do this, if you've never had to comply with an earned sick time obligation before, if you're a smaller employer and you're starting from scratch, if your employees don't have time off that you're planning to allocate to this, or for whatever reason, Warner has written model policies for both large and small employers, and you can purchase those from our business development team. And I think that is it. So